So Companies Act 2013, chapter number 6. This act was brought into picture when the government wanted to change this Companies Act 1956 along with some amendment, as there were new changes and government wanted that we should be competing, Indian economy should be competing with the other countries' economy, and to facilitate the growth and expansion in our Indian economy, central government came up to replace Companies Act 1956 with Companies Act 2013. Due to changes in national and international economic environment and to facilitate expansion and growth of our economy, central government decided to replace the Companies Act 1956 with a new legislation. So they brought a new law. Companies Act 2013 contains 470 sections and 7 schedules. Entire act has been divided into 29 chapters. A substantial part of this act is in the form of companies rule. So this major part of this act is in your companies rule. Okay, it has been divided into 470 sections and 7 schedules, majorly divided into 29 chapters. So this is something you can just keep for your knowledge. They won't ask you anywhere. Companies Act 2013 aims to improve corporate governance, simplify regulations, strengthen the interest of minority investors, and for the first time legislates role of whistleblowers and provisions relating to action against suit. Thus, this enactment seeks to make our corporate regulation more contemporary. Now, why was this enacted? To improve corporate governance. There is a control on the activities done by the companies, to strengthen the interest of minority investors, people who have shares like 1 or 2 shares. I have 2 shares of Tata Motors, but I should be aware what are the transactions going on in the Tata Motors. This information can be obtained by me as an investor when all the compliances are done by the companies. When it is done by the companies, I can check on the MCA website, Ministry of Corporate Affairs website, see what are the things written in the financial statements. I have the access to it. And then first time to legislate to bring in the role of whistleblowers. Whistleblowers are something who ask, who talk to people who are the employees of people, who get to know what is the opinion of other employees about our company. If there is problem going on, they will talk to whistleblowers, tell them. They are kind of well wishers. And provisions relating to class action suit. Thus, in the enactment, this enactment seeks to make our corporate regulations more contemporary, more available to people, and the regulations are more transparent. Okay, is the first para clear?
Ma'am, class action should.
Sorry. And the provisions relating to class action suit. So they can file a suit, and there will be some class of people. Like everyone can't file. There's 1 second. Huh? Please send recorded session. Okay. Yeah. So class action suit means that you can any people, like a group of people. Now 5 shareholders are there, right? They hold only 50 shares. Now, you can't say that a company having 10 lakh of shareholders, 50 shareholders will go and file a case against company if something is going wrong. They will take a representative. They'll make a representative. Small shareholders representative is there. Okay, 1 second. I have to receive my result now, so I can leave the class. Able to attend. Okay, leave the class. I'll send the recording. Message me for recording. So these people get a representative, and they can file a case against the company if something is going wrong. They make a representative. 1,000 shareholders having the 10%, below 10% of shareholding can file a suit against it. Okay, we'll be seeing all those provisions over here. Applicability of the Companies Act 2013. Provisions of the Act shall apply to companies incorporated under this Act or under any previous company law. So, under 1956 Act, if any company is formed, that is also going to be ruled by the Companies Act 2013. And the newly formed companies formed after 2013, 14, 15 will also be covered over here. Insurance companies, except where the provisions of the said Act are inconsistent with the provisions of Insurance Act 1938 or the IRDA Act 1999. Now, here, insurance companies will be included insurance companies will be included. But if the provisions of Companies Act 2013 are not in line with Insurance IRDA Act, Insurance Regulatory Department Act, Development Act, if they are not in compliance with this one, then only Insurance IRDA Act will be applicable, or the Insurance Act 1938 will be applicable. If they are complying with the Companies Act and the provisions are same in both the acts, then you can go with any of the acts. Then you have your banking companies. Banking companies, same thing. For banking companies, it will apply. But if the provisions of the said act, of the Companies Act, is different from the Banking Regulation Act 1949, then these companies will be governed by the Banking Companies Act, Banking Regulation Act 1949. Okay. Now, companies engaged in the generation or supply of electricity. The companies which are engaged in the generation or supply of electricity, your power supply companies will be also included in your Companies Act 2013. Same thing, if the provisions of Companies Act are inconsistent with Electricity Act 2003, that companies will fall only under the Electricity Act 2003 provision. Any other company governed by any special act for the time being in force, any other company is formed and that is governed by any special act that is in time being in force will also comply with Companies Act 2013. Such body corporate which was incorporated by an act for the time being in force and as the central government may by notification specify in this behalf. So your LLP will also be taken care over here. LLP company, or you can call it Section 8 company. Section 8 companies are your not-for-profit companies. So they will also be governed over here. Or if some provisions of LLP are given in the Companies Act, to that LLP, some provisions of company will also be applicable. If tomorrow what happens is Companies Act comes up and says that you can only have 50 members, 50 partners in your LLP. So that provision will apply to LLP also. Okay. Is it clear?
Yes, ma'am.
Let's go ahead. Company meaning and its features. What is a company? What are the features, key elements, essential characteristics will be seen. According to Chief Justice Marshall, a corporation is an artificial being, invisible, intangible, existing only in compilation of law. Now, we'll see one word each. A corporation. Brought together, people are cooperating and bringing up an entity that is a corporation. Is an artificial being. It is not a person, a human being. It is an artificial being. Invisible. You can't see company. Intangible. You can't touch company. Existing only in contemplation of law. Only in interpretation of law. Only in the eyes of law. Being a mere creation of law, company is just created by law. It possesses only those properties which are which the charter of its creation confers upon it. Whatever properties the company's law has given to it, that is only confirmed on it. That is only given to it, either expressly or as accidental to its very existence. Either it is expressly given, like that companies can function is this way, or accidental to its very existence. Accidental means in income tax they have given companies have to file their returns by this date, 30th November, if they are transfer pricing companies. Companies have to comply with specific requirements of income tax. So these are accidental because they are existing as a company. That is why income tax provisions are given. Okay. Is the meaning clear?
Yes, ma'am.
Yes.
Yes, ma'am.
Corporation is an artificial being, invisible, intangible, existing only in the eyes of law or contemplation of law. Next definition by Professor Haney. A company is an incorporated association which is an artificial person created by law, having a separate entity with a perpetual succession and a common seal. This is the most commonly used definition of the companies. A company is an incorporated association which is an artificial person created by law, having a separate entity and with a perpetual succession and a common seal. Okay, so it covers all your major characteristics and features of the company. You can remember here only the features of the company. This definition sums up the meaning as well as features of company succinctly. However, the Act defines the term company a bit differently. Now, these were the definitions given by some professors, some people who are experts in trade and commerce, who are experts in science. So, these people have given it. Now, our Act, Companies Act, has also defined company. Section 220 of the Companies Act 2013 defines the term company. Company means a company incorporated under this act or under any previous company law. They have given a simple definition. Company means a company incorporated under this act or under any previous company law. As we shall progress under the chapter, the meaning of the term company will be understood by the students. Now, while we study, you'll be able to understand what is the meaning of the company. Let's go to features, separate legal entity. We have seen in the previous classes also that companies have a separate legal entity, legally separate from the members. If the members die, the company is not going to stop. The company is still going to continue. Perpetual succession. Change in members does not affect the existence of the company. Even if your members are changing, your company is still going to exist. Company is separate and the members are separate entities. If any case is filed against the company, that does not mean it is filed against the members of the company. Company is an individual, separate legal entity acting on its own. Limited liability. Liability of company is different from liability of members. Company has to pay 10 CR. Members don't have to pay 10 CR. Members, if their amount due is only 10 lakh rupees, so they'll only pay 10 lakh rupees. Artificial judicial person. Company can act through human agency only, and company can contract, sue and be sued in its own name. Company can be sued, or you can sue the company, and company can sue others by its own name. Directors, members will not act as in will not sue other people. Company has a problem. If something is going wrong in the company will have to issue the notice. Like ABC Limited. ABC Limited will issue the notice. ABC Limited will sue other people in their own name. And company can act through human agency only. Directors will act on their behalf. Your members will act on the behalf. Auditors will act on the behalf. That is how a company works. We have seen the definition given to company from a layman's point of view and the legal point of view. But the company form of organization has certain distinctive features, separate features, making it different from other entities. That helps us to understand the realms of the company. Following are the main features. Now they have again explained all these features. We'll just go through them. There are distinctive features between different forms of organizations, and the most striking feature in the company form of organization vis-a-vis the other forms of business organization is that it acquires a unique character of being a separate legal entity. It gets a unique form of a separate legal entity. It has a separate PAN from its members. In other words, where a company is registered, it is clothed with a legal personality. Company gets a legal personality. It comes to have almost the same rights and powers as a human being. They get a PAN, that is their legal personality. This is same like a human being. Its existence is distinct and separate from that of its members. Members are different and the company is different. Company can own property, have bank account, raise the loans, incur liabilities and enter into contracts. A company can buy the property, they can take bank loans, they can have their own bank accounts, they can company can incur the liabilities, can make the expenses and enter into contracts. Okay, clear everyone?
Yes, ma'am.
Okay. It is at law a person which is different from the subscribers of the memorandum of association. By law, you can say company is different from the people who have subscribed to memorandum of association, who have paid the share capital. Its personality is distinct and separate from the personality of those who compose it. The members who become the company members, their personality and company's personality is different. Even members can contract with company, acquire right against it, or incur liability to it. Even these members can get into contract with the company and they can incur liability towards company. If some of the employees take away some money as a loan from the company, then they are liable to pay it to the company. For the debts of the company, only its creditors can sue it and not its members. If company has to pay some amount to its members, then this is because they have taken share capital. So share capital money is that for which you cannot ask that money back. If you are a member of the company, you can't ask that money back. When the company will be winding up, that time the money will be paid. So you don't have the right to sue the company for share capital, because one person invests in the company as a member. That time he cannot sue the company for the liability, for getting the money back. When the company will close, you'll get the money. Otherwise, you can't ask for money. The other thing is, if you want, you can sell the stake, sell the share. That is a different thing. For the debts of the company, only its creditors can sue it. If company has to pay some money to the other people, so only its creditors, that means your bank people, your loan from the where company has taken a loan, or any purchases company has done, that people only can sue it. Members cannot sue the company. Okay. A company is capable of owning, enjoying, and disposing of property in its own name. Company can buy the property, land or building in their own name. They can dispose of the property in their own name. Although the capital and assets are contributed by the shareholders, the company becomes owner of its capital and assets. Even though these members have paid the money, have paid the share capital, your company will become the owner of the assets taken, owner of the share capital amount that is invested. Shareholders are not the private or joint owners of the company's property. Shareholders are not the entire owners or joint owners of the company's property. Whatever property company has, it is company's property. When it will be closed, the shareholders will be paid the money. The shareholders, creditors, etc. Everyone will be paid the money. A member does not even have an insurable interest in the property of the company. The leading case on this point is of Makara versus the Northern Assurance Company Limited. The members who have paid the money, like I told you, someone has invested the capital. But when the company will wind up, then only your capital will be repaid. Or else, if you want, you can share the sell to the company or to anyone else or another person. Till then, you can't get the money, and you can't get the insurance done of this money. This money is of company. You have paid it. Now forget about that money. When the company will close, it will give you back the money. Till then, forget about this, and that money cannot be insured. As you insure a house, you take insurance for a house, but you can't take insurance for the money invested in the company. Okay, is this point clear to you people?
Yes, ma'am.
Yes.
Okay. Let's see this leading case also. 1 second. It has got stuck again. Now, let's see what the case says. Makara M was the holder of nearly all except one share of a timber company. He was a major creditor of the company. Now, this Makara is holding all the shares except one. So, he's holding 99 shares of a timber company. He was also a major creditor of the company. Now, he is the one who is also a major creditor. He is also supplying goods to the company. He is a creditor. M insured the company's timber in his own name. M insured the timber in his own name. Timber was lost in the fire. Now, he insured what? Timber. Now, timber was lost in the fire. M claimed insurance compensation. Held the insurance company was not liable to him, as no shareholder has any right to any item of property owned by the company, for he has no legal or equitable interest in it. Hence, in this case, since the timber was insured in the company's name, M could not claim the compensation from insurance company. Now, what happens over here? The timber lost was suppose of around rupees 5 crore. Now company will say, okay, if your timber is lost, we will pay compensation to timber company. Let's name this timber company. AP Timber Limited, right? They said whatever amount is there, we will pay to this Timber Limited company. We won't pay Mr. M because Mr. M is a shareholder. He's a member. He can't ask for money. Company can ask for money, creditors can ask for money, but you being the shareholder can't ask for them. If you are a creditor, you have to ask the money to the company. You can't ask the insurance company for the money. So what will happen over here? This 5 crore, if it is insured for 90%, 4.5 CR will be paid to the company. And then if the Mr. M wants to close the company because he is 99% shareholder, if he wants, he can close the company and take away this 4.5 crore. So that is why this case law came into picture that members or shareholders cannot file a case or cannot insure their money from the insurance company. Is this case law clear?
Yes, ma'am.
Yes, ma'am.
Let's go ahead. Now, perpetual succession. Even though if the members of the company die or they do not continue as the members of the company, still you can say the company will continue. Members may die or change, but the company goes on till it is wound up on the ground specified by the Act. Until it is said that these situations lead to winding up of the company, till then the company will continue. Even though if members die or change, A was a member, now B became the member, A is not the member, still the company is going to continue. Shares of the company may change hands infinitely, but that does not affect the existence of the company. In the share market, you see some people buy and sell the share on everyday basis. So if I am selling the shares of Tata Motors today and I buy it on the next day also, I am not the shareholder in the one day, like in 1 day's period, I'm not the shareholder. I sold it today, I bought it after 2 days. So for these 2 days, I'm not the shareholder. Will Tata Motors stop? No, it is not going to be affected. Infinitely, the shares will be changing. Shareholders will be changing. Since a company is an artificial person created by law, law alone can bring an end to its life. If law has created someone, law only can end its life. Company is created by law, it will be ending when the law says. Its existence is not affected by death or insolvency of its member. If 10 members become insolvent, then also the company is going to continue. 10 members die, company is going to continue. Simple example they have given. Many companies in India are in existence for over 100 years. This is possible only due to the fact that company has perpetual existence. There was a company which has 7 members and all of them died in an aircraft. Despite this, the company still exists unlike partnership form of business. If all the members have died, still the company is going to continue. The members' hires will come, their heirs, legal representatives will come and run the company. Okay, clear?
Yes, ma'am.
Okay, let's go ahead. Limited life. Liability of member depends upon the kind of company which he is a member of. If the company is a limited liability company, then the liability will be limited, and we know that company is a separate legal entity which is distinct from its members. Members are different and their company is different. Thus, in this case of limited liability company, debts of the company in totality do not become debts of shareholders. If company has to pay 10 crore, it is not compulsory that shareholders also have to pay 10 crore. If shareholders are only liable to pay 5 crore, that is their amount pending for the shares, amount pending to be paid for shares, that is only how much they'll pay. 5 crore it can take as a bank loan, it can take as money from other shareholders, issue new shares and then get the money. That is on the company's part, how company wants to pay that liability. Liability of members of the company is limited to the extent of nominal value of shares held by them. If they are holding shares of 10 rupees and they have not paid the amount entire 10 rupees, they have only paid rupees 6. So the remaining 4 rupees will only be the liability to the extent of the nominal value of shares held by them. If they are holding rupees 10 shares and they have only paid rupees 6, they will only pay rupees 4. If they are holding shares of rupees 10, they have paid only rupees 5. So 5 rupees will be the liability. In no case can the shareholders be asked to pay anything more than the unpaid value of shares. More than the unpaid value of shares, you can't ask any amount to the shareholders. You can't say to shareholders, give me some money for now, I'll return it to you later. That is not possible. If you want to do that, that will be a loan kind of thing. In case of company limited by guarantee, I had explained you that there are companies limited by guarantee. So where company is given guarantee, members are liable only to the extent of amount guaranteed by them, and that too only when the company gets into liquidation. Now, company is limited by guarantee. Shareholders, members have given the guarantee of the company. So whenever this company goes into liquidation, whatever amount is asked to pay, whatever amount was guaranteed, that much amount only will be paid. If you had guaranteed for 50 crore, 10 shareholders, 10 members guaranteed for 50 crore, so only 50 crore will be paid. Even though your liability is 100 crore, you have guaranteed 50 crore, so it will pay only 50 crore to the extent of the amount guaranteed by the members. However, if it is an unlimited company, liability of its member is unlimited as well. Even though we know that companies are known for limited liability, there are some companies which we call it as unlimited company, where the liability of the shareholders is unlimited. Members' liability is unlimited. This point is clear to you people, limited liability?
Yes, ma'am.
Artificial legal person. A company is
Ma'am,
an artificial person. Any doubt?
unlimited company, how they will mention in the name, ma'am?
Sorry? Unlimited company, how?
ABC, like ABC limited company. For unlimited company, how they will mention in the name?
See, for the companies, limited is LTD word is used. For your unlimited, you will not use this words unlimited, and you can write it as ABC and company. That is how you can name it. If you want a few examples, let me find it for you. Like, is there any unlimited company? In India, if we have, usually don't have the unlimited companies over here. No, in India, there is no such unlimited company. I have checked, there is no such unlimited company. Now, this unlimited companies usually you see they become a hybrid of your partnership turning into a company. So that time they firstly form in the unlimited. So they just mention ABC and company. Okay. There's a provision given in the law. So that is why we have to discuss this, that unlimited companies there. But in India, always the companies are limited companies. Okay.
Yes, ma'am.
Artificial legal person. Company is an artificial person created by process other than natural birth. It is legal or judicial as it is created by law. Person, since it is clothed with all the rights of individual. Now, 3 points they have given. Company is a artificial legal person as it is created by a process other than natural birth. So, like company cannot be born. So, it is an artificial legal person. It is a legal or judicial procedure has given right or has created a company, and it becomes an individual. It is called as a person. In income tax, you'll know that person can be an company can be a person, your individual can be a person, partnership can be a person. That's why they are saying it is a person. It acts like an individual. All the rights of individual are given to a company. Further, the company, being a separate legal entity, can own property, have bank account, raise loans, incur liabilities, and enter into contracts. Even members can contract with company or acquire right against it or incur liability to it. It can sue and be sued in its own name. It can do everything which a natural person can do except be sent to jail. You can't send the company to the jail. You can send the directors to the jail, but you can't send the company to the jail. Take an oath, company cannot take an oath. Marry or practice a learned profession. They cannot take a degree also. Company cannot take a degree. Hence, it is a legal person in its own sense. Same definition we have earlier seen also. Like it can take a property, buy a property, have a bank account, can raise the loans, can also incur expenses, liabilities. Company can enter into contracts just like human beings. And every member, even members can contract with the company. What contract is there between salary and in the company? Like the employees and the company have a salary contract between them. Acquire right against it or incur liability to it. Any member can also acquire right against it. They can take some rights against the company also and incur liability to it. They can ask for any liability if they have taken loan from company. That is a liability towards the company. Company can sue and be sued in its own name. Company can sue other people and other people can also sue the company. It can do everything which a natural person can do except send to jail, take an oath, marry, or practice a learned profession. Your CA, CMA degrees, a company cannot take. A company cannot marry other company, and it has a legal. It is a legal person in its own sense, excluding what normal human beings can do. As the company is an artificial person, it can act only through human agency with directors. The directors cannot control affairs of the company and act as its agency, but they are not the agents of the members of the directors can either on their own or through the common seal can authenticate its formal activities. Companies run by the directors, but directors are not the agents of the members. See, if a company is there, it will have the members and members will appoint some directors. But these directors will work for the company, will be agent of the company, but not the members. They will act as an agent of the company, but not the members. These are the directors, two directors of a company, and there are 20,000 members. Right, 20,000 members. So these two directors will be acting for the company A, B, and C Limited. Right, A, B, and C Limited. They will be acting as agent for the company, but not for the members. Okay, is this clear?
I'm having one doubt.
Yeah.
Sole trader can be unlimited liability.
Sole trader, yes, that sole trader is an unlimited liability person only because whatever losses will be there of that sole trader only. Small company can be considered as unlimited liability because you can say that small company is having only one director or one person company. So whatever liability is there is that of that one person. You can call it as unlimited company. It is different from unlimited company because they also mention limited in their name. Still, I am telling you that it can be considered as unlimited liability. Okay.
Okay, ma'am. Okay, ma'am.
Thus, a company is called artificial legal person. So now they can ask you in this question, in this examination, that why is company called an artificial legal person? So you have to mention all 4 points. First point is very easy, that it says that it has a legal structure given by law. Artificial person is someone who is not given birth by a natural process and it takes the shape of an entity. Then second point, you will mention like what things company cannot do. It cannot be sent to jail, it cannot take oath, it cannot marry or practice a learned profession. But company can buy a property, incur liabilities, enter into a contract, it can sell a property, it can also like other people, the members can get into contract with the company. These points you have to mention in the second. And the third point you'll mention, company is operated by some human agency, that is directors, and these directors cannot control affairs of the company and act as its agency, but they are not the agents of the members, they are just the agents of the company. Okay, and directors will work on their own or through the common seal of the company. Okay? All these 4 points you have to mention, 3 points you have to mention. when they ask you define company as a separate legal entity or artificial judicial person. Artificial legal person. Right? They can ask you as a short note over there in the exam. Common seal. A company being an artificial person is not bestowed with a body of natural being. Therefore, it works through the agency of human beings. Because it's an artificial person, it works through the agency of human beings, that is their directors. Common seal is the official signature of the company. They get a seal, round seal is there, or a square seal is there. So that is a symbol of the company, that is the signature of the company, which is affixed by the officers or and employees of the company on its every document. Your directors, your other employees will be affixing this common seal on the company. It may be written ABC and Company Limited. So that is how it works. Okay. Common seal is clear to you people?
Yes, ma'am.
Common seal is a seal used by a corporation as the symbol of its incorporation. Companies Amendment Act 2015 has made the common seal optional by omitting the words and a common seal. Earlier it was the company is having a common seal. Like in the definition we had seen and a common seal. Now these words have been replaced. I'll show you where we used these words. Here you can see it was given and a common seal. Now this words and a common seal is replaced with or a common seal. Okay. This is made as optional. They have omitted this words and a common seal. For section 9, so as to provide an alternative mode of authorization for companies who opt not to have common seal. Some companies say we don't want the common seal, so they will operate without the common seal. Rationale for this amendment is that common seal is seen as a relic of medieval times. From medieval times, we have been seeing the stamps and seal kind of thing. So that's why they said we don't want to do this. Even in the UK, common seal has been made optional since 2006. This amendment provides that the documents which need to be authenticated by a common seal will be required to be done so done only if the company opts to have a common seal. If the company says we don't want a common seal, then the documents will not be authenticated by the company. In case of company does not have a common seal, authorization shall be made by two directors or by a director and a company secretary, wherever the company has appointed a company secretary. Now, if the company does not have a common seal, two of its directors will be signing the documents, or else one director and one company secretary will sign the documents. Wherever company secretary is applicable, the provisions of company secretary appointment is applicable, there these companies will be signed, the documents of that company will be signed by one director and one company secretary, or else both the directors can also sign. Till here, are the concepts clear to you people?
Yes, ma'am.
Yes, ma'am.
Everyone, two people answered. Others, go and check if there is some thumbs up. For dividend, a shareholder can sue the company or not, ma'am? No, dividend you can't sue a shareholder, because if you are not getting the dividend, you have the option of selling the company. Dividend is only paid when the company makes the profits, and if it is not paying dividend from a long period of time, you can question the company. You can't sue the company. Okay, is it clear?
Yes, ma'am.
Now, we'll go with the next concept, corporate veil. So veil means like it's a thin cloth that is covering. So under corporate cover, how the companies are working, we'll see. Corporate veil refers to legal concept whereby the company is identified separately from the members of the company. Now here, this corporate entity name, like you're a company, so that name is covering you and making you a separate person from your members, separate from members. The term corporate veil refers to the concept that the members of company are shielded from the liability connected to a company's action. So the members are shielded, members are protected from the liability of the company. Like the liability that the company incurs is the liability of company itself, not of the members. If the company incurs any debts or contravenes any laws, the corporate veil concept implies that the members should not be liable for those errors. If company is doing some wrong, or if it contravenes the law, if it breaks the law, corporate veil concept says that company is different from the members and members are not liable for acts of company. In other words, they enjoy corporate insulation. They are kept separate from the company. Thus, the shareholders are protected from the acts of the company. If something company does wrong, if Reliance is doing something wrong and I have shares of rupees 5,000 of Reliance, that is, I have nearly 4 shares of Reliance. Now, will I be responsible for everything? No, I only holded 4 shares, that is of 5,000. Company is around 500 crores, 5,000 crores. So, I am not responsible for the acts of company. Okay. Is this corporate veil clear to you?
Yes, ma'am.
Let's go ahead. Whenever you need a break, please tell me. It's 11:57. So if you need a break, let me know. The Salomon versus Salomon and Company Limited laid down the foundation of the concept of corporate veil or independent corporate personality. So this particular case law laid down the role or the concept of corporate veil. Let's see what this case is. In Salomon versus Salomon and Company Limited, House of Lords let down that the company is a person distinct and separate from its members. In this case, one Salomon incorporated a company named Salomon and Company Limited with 7 subscribers consisting of himself, his wife, 4 sons and 1 daughter. Now, Salomon, what he did is, he formed a company, and the company name was Salomon and Company Limited. Now, who are the subscribers? Who are the people who have invested their money in this? Mr. Salomon, Mrs. Salomon, their his wife, 4 sons. These are 6 people and 1 daughter. So they have invested their money. This company took over the personal business assets of Salomon for euro 38,782, and in turn, sorry, not pound, 38,782. Salomon took 20,000 shares for £1 each, debentures worth 10,000 of the company with the charge of company's assets and balance in cash. His wife and daughter and 4 sons took one each share, £1 each share. Subsequently, the company went into liquidation due to the general trade depression. The unsecured creditors to the tune of 7,000 contended that Salomon could not be treated as a secured creditor of the company in respect of the debentures held by him, as he was the managing director of one-man company, which was not different from Salomon, and the cloak of the company was a mere sham and a fraud. It was held by Lord MacNaughton. Now, here what happened is, here the company was not able to perform properly. So, what the creditors said that, okay, Mr. Salomon, you are the only one who is running the company. You are the one-man company. This company is a one-man company. You are running this business. You are not responsible for being paid first. You won't be paid for the debentures. Now, there is a sequence when they make the payment. They make the payment for preferential creditors. Preferential creditors are your banks, your government people. All these are your first priority to whom the amount is paid. Then the amount is paid to debentures. Then it is paid to creditors. Now, if it is paid to debentures and Salomon holds the debentures, what the other creditors are saying, you are already the owner of the company. You won't take the money. He says, I am different. Company is different. Company and its subscribers are 2 different people. They are different person altogether from the company. Okay, is this para clear to you people?
Yes, ma'am.
company is at law a different person altogether from the subscribers of the memorandum. Whosoever subscribes the memorandum of the company is different from the company. They are not the same people. Then, and though it may be that after incorporation of the business is precisely the same as it was before, and the same person are managers, and the same hands receive the profit, the company is one second. The same person are managers and the same hands receive the profit. The company is not in law the agent of the subscribers or trustees for them, nor are the subscribers as members liable in any shape or form except to the extent and in the manner provided by the Act. If they have unpaid amount from rupees 10 share, they have only paid rupees 6, so they'll be only liable for rupees 4 as provided in the law. In the law, it is said that you are liable for only the unpaid amount. So whatsoever amount is liable to the company is payable by the company. Company will pay from its own funds. Members will not use their fund. Thus, in this case, this case clearly established that company has its own existence, and as a result, a shareholder cannot be held liable for the acts of the company, even though he holds virtually the entire share capital. Even though all the members of the family, Salomon family, have the shares of the company, still these subscribers, these people are different from the company, and they will not be liable any day for the acts of company. Whole law of corporation is in fact based on this theory of separate corporate entity. The entire company law was established because they wanted people and company to be separate legal entities. Okay, till here is this point clear? Is
Yes, ma'am.
Now the question may arise whether this veil of corporate personality can even be lifted or pierced. Can we make this veil of corporate personality, what is given that company is different and this person is different, can we lift it up or can we pierce it? That means can we remove that separate entity thing and make them behave together? Before going into this question, one should first try to understand the meaning of the phrase lifting the veil. What is lifting the veil? That means to uncover something. Like women usually cover their heads. So that is a veil kind of thing they wear. So now we have to remove that veil. Now let's see what in law it means to lift a veil. It means looking behind the company as a legal person, that is disregarding the corporate entity and paying regard instead to the realities behind the legal facet. Lifting of veil happens usually when the company is suspected to have committed a fraud. When the government thinks or when the creditors think that the company is doing fraud, the people who are members of the company are doing a fraud, that time we lift the veil. When we want to go into realities, is companies only acting or the members, directors are acting as such? Where the courts ignore the company and concern themselves directly with the members or managers, the corporate veil may be said to have been lifted. Now, what the court says, court will talk to company, court can talk to company or not? Can they talk to company? Can court talk to company? Yes or no? Will company speak up anything?
No, no.
No, company does not have that human quality of speaking. So who will court contact? Members, directors, right? So these people are the representatives, they are the agents. That is where court has lifted the veil. Court will say, we don't know who's a company. You are the director, you have to talk over here. You are the member, you have to talk over here. That is where courts lift the veil of the corporate, veil of corporate personality. Only in appropriate circumstances, courts are willing to lift the corporate veil, and that too when questions of control are involved rather than merely a question of ownership. When the question of ownership is there, they know that it is members. But when it comes to functions of the company, if company is doing something wrong, that time the court will have to lift the corporate veil, because the work that is done, the control that is exercised by the company is a problematic thing. That is where they are going wrong and the company is doing wrong. Who does wrong? Directors, members do wrong, but on the face of company, on the name of company. Next point is lifting of corporate veil. The following are the cases where the company law disregards the principle of corporate personality, or the principle that the company is a legal entity distinct and separate from its shareholders or company. So in these cases, you can't say that company is a separate entity. To determine the character of company, that is to find out whether the co-enemy or friend. In the law relating to trading with the enemy, where the test of control is adapted, leading case in this point is Daimler Company Limited versus Continental Tire and Rubber Company. If the public interest is not likely to be in jeopardy, court may not be willing to crack the corporate shell, but it may rend the will for ascertaining whether a company is an enemy company. It is true that unlike a natural person, a company does not have mind or conscience. Therefore, it cannot be a friend or foe. It may, however, be characterized as an enemy company if its affairs are under the control of people of enemy country. For this purpose, court may examine the character of persons who are really at the helm of the affairs of the company. Too much they have said. Now, Daimler Company Limited and Continental Tire and Rubber Company. This was a leading case which said that if, suppose we'll take this only. Sorry, Daimler. Taken the name wrong. 1 second. Here, Daimler Company Limited. Right now, this company is having shareholders. Their names are A, B, and C. So these people are belonging to China. Now we got to know that the COVID situation happened due to China, the wrong of China. Right? This China people did wrong. So these are the people of China are enemy for India. Right? They are acting as an enemy for India because they are trying to harm the nation. They are trying to harm the entire world. So they are enemy to us. So if the company feels that Daimler Company, if the court feels that Daimler Company Limited is working through A, B, and C, who are the people of China, who are residents of China, they are working to make like the company, they are getting into company contract with other people, or they are making contracts with Indian people to harm India, where they are trying to be enemies of India, where they are trying to control the people of India in a wrong manner. That time you can say that company is not a separate legal entity. People who are running the company and the company are same people over here. They are not different persons. If its affairs are under the control of the enemy country, China is an enemy country and the control is in the hands of enemy country. For this purpose, court may examine the character of persons who are really at the helm of the affairs. These are the people who are working. So court will question character. Character means they'll know what is this people, who, where do they come from. If they are from China, so for how long they are working in China, how is their behavior towards the Chinese and the Indian people. All these things will be asked. Is this first point clear?
Yes, ma'am.
We have to know that is company, like the original company that is being operated, is it the Indian company or an enemy company is trying to control our companies? We have to know the status. To protect the revenue or tax in certain matters concerning the law of taxes, duties, and stamps, particularly where the question of controlling his interest is an issue. S. Brenson Limited versus Commissioner of Inland Revenue. Where a corporate entity is used to evade or circumvent tax, the court can disregard the corporate entity. Jugilal versus Commissioner of Income Tax. Now, what person was doing? Person knows that I am 50 years, right? And he is getting the amount of 2 crore for the sales. If he does a proprietor business, he will be taxed as a lot of money will be taxed on this 2 crore. He will have to pay nearly around 30%, 65 lakh rupees he'll have to pay, right? 65 lakhs I'm considering he'll have to pay. But he says that if I get into a company, this 2 crore that I'm receiving will be getting some expenses. I will be able to take the deduction of expenses. I will be able to claim more depreciation. These all are income tax things which I'm telling you. So there, the tax will be there. If I make a company, the tax will be only 45 lakh. He will say, I will be able to save 20 lakh. Save 20 lakh rupees if I do not work as a proprietor, but if I work as a company. So where the people are trying to invade the tax, they're trying to take the advantage of tax provisions by making a company. They will be saying, the government will be saying, the courts will be saying that person and the company are same. There will be no separate legal entity. Next is in Dinshaw Mansekji Petite, it was held that company was not a genuine company at all, but merely the assessee himself disguised under the legal entity of a limited company. Assessee earned a huge income by way of dividends and interest. So he opened some companies and purchased their shares in exchange of his income by way of dividend and interest. This income was transferred back to assessee by way of loan. The court decided that the private companies were sham and the corporate will was lifted to decide the real owner of the company. So this was the example where income tax was invaded in the first case. In the other case, what happened is a person has shares. Now, let me take an example once again. So the first one is clear to you, Jugilal versus Commissioner of Income Tax.
Yes, ma'am.
Able to use the eraser. Here what happened? A was earning interest and dividend. He had shares of multiple companies, so he was earning dividends, and interest. So what he did is he knows that I will be taxed at a higher rate and all this amount is coming in the hands of me. So what he does, he makes A and Company Limited. Now he sells all these shares, sells the shares. Now who is going to earn the dividend and interest? A and Company. Then what they do is A and Company gives loan to A. Now this money which was earned as a dividend now is given as a loan to Mr. A. Now A will have to take the advantage of interest. He can claim a deduction of interest. He will be able to take the deduction of interest and his expenses, his income will be reduced. That is where this separate legal entity concept will not be applicable, because A is the owner of A and Company and now again he's taking loan from the company. So if any loan is given to the director and that is higher from the profits amount, that will be considered as the income of that assessee. Now that is all income tax thing. For you to explain, I can just say that he transferred the shares to A and Company Limited, and when he has transferred the shares to A and Company Limited, income will be taxed in the hands of A and Company. Mr. A will not have to pay the tax on this income. That is where he's trying to save the income. That is where he's trying to save the amount of income tax. Okay. Is this
Yes,
point
ma'am.
clear? Then he again takes that money from the company as a loan. Then company will get the interest that will be taxed in the hands of company. And this person, he is taking all the money but not paying any taxes, because company will pay tax. And how much company will pay tax is less than the tax that will be applicable on the individual income. Okay, I hope this point is clear. Let's move ahead with the next point to avoid legal obligation. Company does not want, the individual does not want his name to be coming into legal obligations. He does not want a case to be filed against him. That is why he does the things on company's name. Where it was found that the sole purpose for the formation of company was to use it as a device to reduce the amount to be paid by way of bonus to workmen, Supreme Court upheld the piercing of the will to look at the real transaction. Now, bonuses are paid to the workmen. So private limited companies have to pay bonuses, and the other companies have to pay. So somewhere they get a advantage. Like if you are a company, if you are not a manufacturer trader, you are a company, you have to pay limited amount of bonuses to the workmen. So when that is a case where it helps you to reduce the amount of workmen bonus, that time you can not consider company as a separate legal entity and the sole person like the proprietor as a separate legal entity. Both of them will be same person. Case law that they have given is the workmen employed in Associated Rubber Industries Limited, Bhavnagar versus the Associated Rubber Industries Limited, Bhavnagar and another. Workmen of Associated Rubber Industry Limited versus Associated Rubber Industry Limited. Facts of the case are that A Limited purchased shares of B Limited by investing a sum of 4,50,000. Dividend in respect of these shares was shown in the profit and loss account of the company year after year. It was taken into account for the purpose of calculating the bonus payable to workmen of the company. Sometimes in 1968, the company transferred shares of B Limited to C Limited, a subsidiary wholly owned by it. Thus, the dividend income did not find place in profit and loss account of A Limited, with the result that the surplus available for the purpose of payment of bonus to the workmen got reduced. Here, a company created a subsidiary and transferred to it its investments holding in a bid to reduce its liability to pay the bonus to its workers. Thus, the Supreme Court brushed aside the separate existence of the subsidiary company. New company so formed had no assets of its own except those transferred to it by the principal company, with no business or income of its own except receiving dividends from shares transferred to it by the principal company and serving no purpose except to reduce the gross profit of principal company so as to reduce the amount paid as bonus to work. Now, A Limited was getting some bonuses, right? It was getting some bonuses. Sorry, B Limited was getting some interest and dividend, not bonuses, interest and dividend. A Limited purchased B Limited. Now, when A Limited purchased B Limited was getting some dividend and interest money. So, if it is getting some dividend and interest money that is credited to our profit and loss account, then profit will increase, right? Net profit increases if we get some income. Yes or no?
Yes, ma'am.
Yes. Now income has increased. Now if your income has increased, you will have to pay more bonus, right? Now to avoid this bonus, what A Limited does is, A Limited transfers this to C Limited to reduce the bonus amount. Here there are no employees. Here there are no employees. If it is doing that, there is no employees over here in C Limited, then who will get the bonus? No one will get the bonus because B Limited, all the shares are transferred to C Limited. All the amounts, everything is transferred to C Limited. There they will not have to pay the bonus. That is where company tried to escape from the liability of bonuses to workmen. And that is why it is considered that C Limited is not a separate legal entity. It is same of A Limited because A Limited has sold B Limited to C Limited. So A Limited and C Limited are one at the same thing. There is no separate legal entity of C Limited. Okay. Is this point clear?
Yes, ma'am.
Yes, ma'am.
Formation of subsidiaries to act as agent. Okay. If you guys need a break, just tell me. Okay. formation of subsidiaries to act as agent. A company has may sometimes be regarded as an agent or trustee of its members or of another company, and may therefore be deemed to have lost its individuality in favor of its principal. Here, the principal will be held liable for the acts of the company. Sometimes what happens, company acts as an agent for the trustees or members. Company is run by the members, then your directors run the company. So it can be said that company is acting on behalf of their principal, that is the members. That time, if company is acting on behalf of its principal or members, you can hold liable the principal. I told you example of Vijay Mallya of Kingfisher Airlines. So Kingfisher Airlines was like exporting gold, etc. kind of things, and it was doing on a cheaper rate. So in that particular case, whatever fraud this company was doing, that time you can say that company is not separate from the person who is running the company. This work was done. Airlines was being run by Vijay Mallya, and he was getting the gold from outside countries, or he was exporting the gold to outside countries. So if he is doing so, he is exporting the gold to outside countries. That is, he is doing the fraud. That's why you can't hold the Kingfisher Limited as a different entity and Mr. Vijay Mallya as a different entity. Both of them are same because company is behaving, company is acting in favor of Vijay Mallya. Is this point clear?
Yes, ma'am.
Yes, ma'am.
Let me explain you with the case law that they have given. In case of Merchandise Transport Limited versus British Transport Commission 1982, a transport company wanted to obtain license for its vehicle but could not do so if applied in its own name. It therefore formed a subsidiary company. A transportation company wanted to obtain license for vehicles. It was not able to get the license for itself, so it made a subsidiary company. It made a different company under it, and the application of for license was made in the name of subsidiary. Vehicles were to be transferred to the subsidiary company. Held, the parent and subsidiary were one commercial unit, and the application for license was rejected. Now, with a basic example, I'll tell you, like if A is the father, A is father, and he cannot buy the vehicle, so Mr. B, that is A's son, he can take the license. So he takes the license. Similar manner, principal company cannot buy the license for the trucks they want to buy, for the transport vehicle that they want to buy. So they will make a subsidiary and tell subsidiary to buy the trucks. Here, what has happened? Parent and subsidiary are same unit only. So the license will be rejected. When the company who is giving the license, when the government gets to know, okay, B is the subsidiary of A, that means A is the fraud company. We don't want to give license. They will reject the license. Next is when company formed for fraud, improper conduct, or to defeat law. When the purpose of creating a company is illegal and you want to commit a fraud, that time you will say that corporate will be lifted and you will be considered as same person of that of company. The person who is forming the company is the same person who is running the company. Where the device of incorporation is adopted for some illegal or improper purpose, to defeat or circumvent law, to defraud creditors, or to avoid legal obligations. Guilford Motor Company versus Horne. That time you can say that if you're doing forming a company to do illegal activities, if a company is formed for buying illegal guns, so if that illegal guns company is formed, that means the person who has formed the company and that company are same people only. They are not distinct people. Okay, is this point clear?
Yes, ma'am.
All the 5 points that we discussed for corporate will are clear to you people?
Yes, ma'am.
Okay, so now would you like to continue or you need a break, because it's 1.5 hours. So if you people are tired of it, you can tell me. We can take a small break or a lengthy break you want. However, tell me.
A small break.
Small break. 10 minutes is okay, or like 15 minutes you need? How much?
15 minutes, ma'am.
50. Meenakshi says 50. Okay, it's 12:25. Should we resume at 12:40?
Yes, ma'am.
Okay, ma'am.
Okay, so we'll resume at 12:40. I'll stop the recording for now and then we'll resume. So on the basis of liability, company limited by share, as we have earlier seen the example, that if some amount is unpaid by the shareholder, only that much amount will be called upon on the basis of liability of the company which is limited by share. Limited by share means limited by the shareholding amount that is unpaid. It may be worthwhile to know that though a shareholder is the co-owners, the shareholder is the co-owner of the company, he is not a co-owner of the company's assets. The ownership of the asset remains with the company because of its nature as a legal person. The ownership of the assets is with the company. Your shareholders can't say we are owner of the property that is there of Reliance. Reliance has Reliance built a new mall. They made Geo World. So you can't say I am the owner of Geo World. It is of the company Reliance Group. It is Reliance's asset. The extent of rights and duties of a shareholder as co-owner is measured by his shareholding. If you are holding only 10%, rupees 1 lakh share, right? That is only 10% of company. So your shareholding will determine what rights and duties one has. If someone has 55% of shares of the company, so he will be indirectly called as the owner of the company, because like person controlling the aspects of the company, person having the control on the operations of the company, because he's having major stake in the company. Okay, is this one clear? Company limited by shares.
Yes, ma'am.
Okay, let's go ahead. Company limited by guarantee. Okay, this is the company limited by guarantee. Section 221 of the Companies Act 2013 defines it as the company having the liability of its members limited by the memorandum to such amount as the members may respectively undertake by the memorandum to contribute to the assets of the company in the event of being wound up. When the company will be wound up, whatever amount they have said we will be paying this as a guarantee, that much amount they will be paying when the company is being wound up. They said that if the company winds up, we will be paying 5 crore rupees each. This four people said. So only rupees 20 crore will be paid by the members. Thus, the liability of a member of a guarantee company is limited up to a stipulated sum mentioned in the memorandum. In the MOA, Memorandum of Association, if it is written, companies will, four of the members will come and pay rupees 5 crore each on the winding up. They will pay only 5 crore each on the winding up. Members cannot be called upon to contribute beyond the stipulated. You can't say the liabilities of rupees 40 crore, please pay more than that. Please pay 10 crore each. You can't tell them because they had their liability already mentioned and they can't pay any more amount than that. Okay. Why did this happen? One second. Okay, give me 1 second. We'll download the PDF and work on it. Still the screen is blank for you people, right? So thus the liability of a member of a guarantee company is limited up to a stipulated sum. So I told you that you can only make them pay to that stipulated sum that they had promised. Common features between a guarantee company and the company having its share capital are legal personality. Both of them are going to act as the company and are limited liability company. Here the liability will be only of the amount that is specified in the company by guarantee, and the other one, company limited by shares, the amount that is unpaid. So both will have limited liability. Liability is not unlimited. In the later case, the member's liability is limited by the amount remaining unpaid, which each member holds. Both of them have to state in their memorandum that the member's liability is limited. You have to write in the memorandum also, member's liability is limited. Clear?
Yes, ma'am.
However, the point of distinction between these two companies is that in the former case, the members may be called upon to discharge the liability only after commencement of the winding up and only subject to certain conditions. But in the later case, they may be called upon to do so at any time, either during the company's lifetime or during its winding up. Now, when guarantee is given, this will be called upon, people will be called upon only on winding up. Okay? When the companies will be wound up, that time only you will call the people members for guarantee. But if amount of rupees 4 is unpaid and you have 1 lakh shares and you need 4 lakh rupees, so then you can call your shareholders. Call the shareholders. Call the shareholders means tell them to pay the amount. It is clear from the definition of the guarantee company that it does not raise its initial working funds from its members. Here, the money will not be received from the members when you are forming the company. Usually what happens when a company is formed, your people will come and pay the money. Like there are 10 shareholders, suppose. So they will come and pay the money. This 10 shareholders will come and pay the money. 10 lakh each or how much it is distributed. All these people come and make the company. Right? The company is made only after payment of the money by shareholders. But in guarantee companies, they don't take money from the members. They raise the funds from the banks. They get the money from the government as a loan, as a grant, as a lease. That type they get the money and then start the company. Therefore, such a company may be useful only when no working funds are needed or where these funds can be held from other sources like endowment, fee, charges, donations, etc. Where the company is working online, they don't need a setup or anything. So what they'll do, they won't ask the members for the money. What they'll do, they'll just work and get the fees, they'll get the donations, they'll get the endowments that is from the government, etc. Okay. Then you have a case law for the limited company by guarantee. In Narendra Kumar Agrawal versus Saroj Malu, Supreme Court has laid down that the right of a guarantee company to refuse to accept the transfer by a member of his interest in the company is on a different footing than the company limited by shares. Membership of a guarantee company may carry privileges much different from those of ordinary shareholders. In the company by shareholders, you can transfer the shares any day. Every time you can transfer the shares, etc. The guarantee amount may be greater than share amount or less. It is definitely greater than the share amount because share value can be your 100, 200, these are the amounts. But in guarantee, what happens when it is called upon winding up? So people form the companies by guarantee because they know that if something goes wrong in the company, we may need funds. So your that amount which is called upon and winding up will be way much higher. Guarantee they take from banks, from the people who are there. What you call it, the name angel investors are there. You might have heard this angel investor words. Have you heard angel investors?
No, ma'am.
So what happens is these people are your family members, your friends, etc. They give the guarantee. Like if the company does not work, I will pay the money. If it winding up, you require any money, we will pay. Got it?
Yes, ma'am.
So if you are transferring the rights, if a member is transferring the rights in company limited by shares, it can be easily transferred. If I am having the shares today, tomorrow I can sell it to Gopika. Then I can sell it next day, Gopika can sell it to Meenakshi. This can happen. But when it is by guarantee, this is not like easily available. The option is not easily available, because if you are giving a guarantee, you get the privileges also. You are giving the guarantee, so you'll get some interest, you'll get some benefits because you are giving the guarantee. So all these things are to be kept in mind. Then you have your unlimited company. Section 292 of the Companies Act 2013 defines unlimited company as a company not having any limit on the liability of its members. Members can sell their house and bring the money. In such a case, the liability of a member ceases when he ceases to be a member. If a member has transferred his shares to another person, then his liability will come to an end. Liability of each member extends to whole amount of company's debts and liabilities, but he will be entitled to claim contribution from other members. So all the members, like 2-3 members are there, so all of them have to contribute to the company's debts. Okay. In case the company has share capital, articles of association must state that the amount of share capital and amount of each share. So if there is one thing called as articles of association, how the company will be working, that is mentioned in the articles of association. So there they have to mention amount of share capital, how much is the share capital, and what is the amount of each share, 100 rupees, 20 rupees, 10 rupees, everything is to be mentioned. So long as the company is a going concern, the liability on the shares is the only liability which can be enforced by the company. If it is a going concern, like the company is going to work for 10 more years, 20 more years, or it is not that the company is going to stop, then the liability of the people, liability of members is towards the share amount. Like I told you, 10 rupees share is there and only 6 is paid. So you can ask them to pay rupees 4 if you need it, because now we are just in need of funds. We are not closing the company. Creditors can institute proceedings for winding up of the company for their claim. If creditors say now close the company and give us entire money, that time you can ask for any amount. Instead of 4, you can also ask them for rupees 40 because you need it. The official liquidator may call the members for their contribution towards the liabilities and debts of company, which can be unlimited. That time when you are closing, official liquidator is someone who helps you to close the company and get the amount paid to everyone, like all the creditors, banks, your government, all the taxes, everything is paid when the liquidator tries to close the company. A liquidator helps you in closing the company when the company is wound up. So that time you can say that the liability will be unlimited. The company will call all the members to pay the money. Are these points clear? Are these points clear to everyone?
Yes, ma'am.
So here, no liability, no limit on liability of members. The liability ceases when the person is not a member. Liability is not unlimited until the time company is not wound up. Until the time company is working, your liability is not unlimited. Till then, your liability is limited. But when it comes to winding up, your liability will be unlimited. Members can be called to contribute only in the event of winding up. Liability of each member extend to amount of company's debts and liability. If the company has to pay rupees 40 crore and there are 10 shareholders, so each of them will have to contribute rupees 4 crores. However, he can claim contribution from other members. So all the 10 shareholders will come together and pay the money. When corporate will lift, the limited company becomes unlimited or not. Okay, when the corporate veil is lifted, you can say it becomes indirectly unlimited. Like you can say, what else is the distinction between the people? Because now when winding it up is happening, now corporate veil can be lifted when fraud is done. If fraud is done, it is not compulsory that the company will be wind up. But generally, unlimited company or the liability is said to be unlimited only at the time of winding up. Okay, so it can take a form of unlimited company, but usually you can't name it like the company corporate will is listed. That means it is an unlimited company. Okay.
Okay.
On the basis of member. So, in a company, if only single person has incorporated a company, then it will be called as one person company. A new class of companies was incorporated, and that by if it is incorporated by a single person, you call it as one person company. Section 262 defines one person company as a company which has only one person as the member. Only one member has paid the amount of capital. One person company has been introduced to encourage entrepreneurship and corporatization of business. When the Company Act wanted that more of the companies should be made and some entrepreneurs should be encouraged that they do the business, that is why they gave a rise to one person company. They always have an option of proprietorship, but company says, okay, if you are one person company, you have to do very less compliances. You don't have to file this return, that return, so that the people will be interested in forming the company. One person company has been introduced to encourage entrepreneurship and corporatization of business. OPC differs from sole proprietary concerns in an aspect that OPC is a separate legal entity. Even though one person is the member, company is different, member is different, separate legal entity with a limited liability of the member, whereas in case of sole proprietary, the liability of the person is unrestricted, and it extends, is not restricted, and it extends to the owner's entire assets, consulting of official and personal. So if you are a one person company, your liability will be limited. But if you are a sole proprietor, the liability is unlimited, not restricted. And even though you don't have money, you have to sell off your house, property, etc., and give the money. The procedural requirements of an OPC are simplified through exemptions provided under the Act in comparison to other forms of companies. So when you are running a company which is a one person company, you have a lot many exemptions that you don't have to file this return, you don't have to comply with this policies, etc. According to Section 31C of the Companies Act 2013, OPC is a private limited company with minimum paid up share capital as may be prescribed and having one member. OPC is a private limited company, not public limited, private limited company. Now we'll be seeing how it is. With a minimum paid share capital, the amount is also less. Minimum paid share capital is there as may be prescribed and having one member. Only one member is there. So key points you need to remember for OPC: only one person as a member, minimum paid up capital, no limit is prescribed that you should have like 5 crore only or 2 crore, 5 lakh rupees only. Nothing is given. Memorandum of OPC shall indicate the name of the person who shall, in the event of the subscriber's death or his incapacity to contract, become the member of the company. So your memorandum of association, MOA, shall indicate the name of the person who in the event of subscriber's death. If A has made a one person company, OPC company, so if A dies, who will be taking the care? That is to be written in the MOA. Who will be taking the capacity of the contract, their name is to be mentioned over. Or his incapacity to contract become the member of the company. If he becomes insolvent, or if he becomes insane, if something happens to him, if there is death case, so who is going to take forward the company? It is to be written in the memorandum of association. The other person whose name is given in the memorandum shall give his prior return concern in the prescribed form, and the same shall be filled with Registrar of Companies at the time of incorporation of the company, along with its e-memorandum and e-articles. Now, here, when you are filing, you are saying that if A dies or something happens to A, B will be the person in charge. If you are making B as the person in charge, you have to tell it to Registrar of Companies, ROC. ROC is Registrar of Companies. You have to tell them this person, Mr. B, has to give a written consent. He has to say, okay, I agree. So he has to give a written consent also. And this has to be done at the time of incorporation. When A forms A Limited, that time this is to be filed. Your alternative person or the nominee person, these things have to be filed while you are incorporating the one person company. Okay, along with e-memorandum and e-articles. E-memorandum is something online memorandum of association. E-articles is online or electronic form of articles of association. Such other person may be given the right to withdraw his consent. This person, Mr. B, if he wants, he can withdraw his consent also. The member of OPC may at any time change the name of such other person by giving notice to the company, and the company shall intimate the same to registrar. If A wants, I don't want B to be person, I want C to be my person after I die, then he can tell Mr. B by sending a notice that I don't want you to be the person of nominee. I will make C as my nominee, and this has to be informed to ROC also. Any such change in the name of person shall not be deemed to be an alteration of memorandum. This does not mean that you are changing the memorandum. Only a natural person who is an Indian citizen, whether resident in India or otherwise, can be your nominee. Your natural person. Company cannot make other company as their nominee. You have to make it as a natural person only, a human being only, to act on your behalf. Okay. Otherwise, and has stayed in India for a period of not less than 120 days during the immediately preceding financial year. So this person has to stay in India for around 120 days. He should be a resident. We have seen this resident definition earlier also. So 120 days is the limit. Shall be eligible to incorporate an OPC. This person can only make OPC and shall be nominee for the sole member of OPC. As I explained you about sole member, OPC also has, like, the member also has to comply with this thing. He should be a natural person, then Indian citizen, and resident in India, or otherwise he has to stay 120 days in India. Right? These are the 4 conditions which one needs to satisfy to like be a member of the OPC or nominee of the sole member of OPC. Clear, everyone?
Yes, ma'am.
OPC is clear to you all? One only said yes. They may ask you it as a definition kind of a thing. Like they can ask you for a short note. What is an OPC company? What are the significant points? They can ask you this thing in examination. There are a few more points. No person shall be eligible to incorporate more than one OPC or become nominee in more than one person. If A is there, he can only make one OPC. He can't make 2 OPCs, right? OPC number 2. This is not possible. Only this. And he can be nominee. If he is not a OPC, he is not member of OPC, he can only make be a member of one OPC. He can't be member of more than one OPC. No minor shall become a member or nominee of OPC or can hold share in the beneficial interest. Minor is not allowed. Such company cannot be incorporated or contravened into company under Section 8 of the Act, though it may be converted to private or public limited companies in certain cases. This type of companies cannot be considered as a Section 8 company. They will not be converted into a Section 8 company. That means company who are running for not for profit business. If they can't become an NGO. They can convert themselves into private or public companies, that will work. Such company cannot carry out non-banking financial investment activities, including investment in securities of any body corporate. This company cannot invest in the securities of other companies, other body corporates. Okay. Is this OPC clear? Is OPC entirely clear? These 4 points are clear to you people. Any doubt in these 4 points?
No doubt.
So a simple chart has been given by ICI. One member company, private company in nature, encourages entrepreneurship and corporatization of business. Procedural requirements are simplified through exemptions, separate legal entity and limited life. Okay. All these key points you can remember when they ask you for a short note on one person company. Okay. This was one company. Now we have private company. Private company means a company having a minimum share capital as may be prescribed and which by its article restricts the right to transfer a share. You can't freely transfer the shares of the company. That time you can call it as a private company. It has a minimum paid up share capital. They will give you a specified amount. This much only can be your share capital. You can't exceed this amount of share capital. Except in case of one person company, limits the number of its members to 200. One person company can only have one member, but private limited company can have maximum 200 members. Maximum that members are required is 200. Like that can be the members of this company is 200. Minimum 2, maximum 200. You can remember like this. Minimum 2, maximum 200 members. Right? Maximum 200 members can be there. Provided that where two or more persons hold one or more shares in a company jointly, they shall for the purpose of this clause be treated as single member. Now here what happens? They said minimum 2 members are required. Now minimum 2 shareholders can be there or 5 shareholders can be there. A and B, they do not have enough money. What they say is, if the share is of 10 rupees, I will pay 5 rupees, you pay 5 rupees. Together we will hold one share. Right? Now together they are holding one share. In this, both of them will be considered as one. Either A or B. Only one will be considered. Both of them can't be considered as shareholders. Only one will be considered. Single member will be considered. Okay. Provided further that person who are in employment of the company and person who have been formerly in the employment of the company were members of the company while in that employment and have continued to be members after employment ceased shall not be included in the number of members, and prohibits any invitation to the public to subscribe for any securities of the company. It says that if the employees were earlier members of the company and now they are not the members of the company, they are not to be included in the number of members. Employees can work for the company, but they will not be included as members of the company. And you can't call public to subscribe to your shares. They can't come and pay the money. If you want public to come and invest the money in your business, make it a public company. Okay, private company is clear to you? Is private company clear to you all? Please say yes or no. Just stuck for a minute. Okay. Now, am I audible? Is it still stuck?
Now audible.
Now audible. So, let's sum up private company in few points so that we will be asking you if it is clear. No minimum paid up share capital requirement. Like you don't have any minimum paid up capital. You can have 10 crore, 1000 crore or 100 crore. Anything can be your minimum paid up capital requirement. Minimum number of members 2, except if private company is an OPC, there will be only one member. Maximum number of members, how much you can have? You can have maximum 200, right? Excluding present employee come members and erstwhile employee come members. Your employees will not be considered as members. Then right to transfer shares is restricted. You have to take permission when you transfer the shares. Prohibition on invitation to subscribe to securities of company. You can't tell Mr. A, M, N, O, P, come and subscribe to our company. You have a private limited company. Outsiders can't come and subscribe to the shares. Small company is a private company. We'll be seeing what a small company is. OPC can be formed only as a private company. If you want to make a OPC, it is only going to be private company. Public company you can't make. You can convert into public company. OPC can become public company. OPC, when it registers, it is only private company. It can convert into two options, private or public. Okay. But when you register a OPC, it has to be a private company. Is private company clear? Is private company clear to you all? Still stuck? Yes.
No.
Small company. Small company given under the section 285 of the Companies Act 2013, which means a company other than public company. And chat is clear. Okay. Yeah. So your means a company other than a public company. Small company means other than a public company, paid up share capital of which does not exceed 50 lakh or such higher amount as may be prescribed, which shall not be more than 10 crore. Now, what is prescribed limit? If your turnover, paid up share capital, we call it PUSC, is up to 50 lakhs, right? Paid up share capital is less than 50 lakhs. Then you can say it is a small company. Now, this is the limit given by government. Government can increase that limit up to rupees 10 crore. Now, it is not a limit, but they can extend up to 10 crore. Turnover of which, as per profit and loss account for the immediate preceding financial year, does not exceed 2 crore. Turnover, T/O is written for turnover. Turnover cannot exceed rupees 2 crore. It should be maximum rupees 2 crore. Or such higher amount as may be prescribed, which shall not be more than 100 crore rupees. And government has the right, they can make it 100 crore also. For us to remember, basic is 50 lakh rupees paid up share capital and turnover 2 crore. Okay? Clear everyone? This clause shall not apply to a holding or a subsidiary company, a company registered under Section 8, or a company or body corporate governed by any of the special act. These companies, like these clauses of turnover and paid up share capital, are not applicable to holding subsidiary company, company which is registered under Section 8, that is a company for a not-for-profit organization, a company or body corporate governed by any special act. If there is some special act, they will not be considered under your small company. Okay, holding subsidiary is not a small company. Then your Section 8 company is also not a small company. For the purpose of subclause 1 and subclause 2 of clause 85 of Section 2 of the Act, paid up capital and turnover of small company shall not exceed rupees 4 crore and rupees 40 crores respectively. Company specification of definition details, Amendment Rule 2022 with effect from 15 September. Now, this definition of paid up share capital now has become rupees 4 crore. So the limit you have to remember is 4 crore and this limit has become 40 crores. Okay. They had the power to increase till 10 crore. Now these limits have become 4 crore and 40 crore. This 50 lakh has become 4 crore and 2 crore has become 40 crores. Okay. So they are summing up: a private company paid up share capital not more than 50 lakh, turnover not more than 2 crore. This was actually originally written. So when you write the answer, you have to consider the original one only. Should not be a Section 8 company, holding or subsidiary company, or company governed by any other act. Is small company clear to you people?
Yes, ma'am.
Then we'll go to public company. Public company means a company which is not a private company, which is open for the public to come and subscribe to the shares. Which is not a private company, having a minimum paid up share capital as may be prescribed. They will give you a minimum paid up share capital. Provided that the company which is a subsidiary of a company, not being a private company, shall be deemed to be a public company for the purpose of this act, even where such subsidiary companies continues to be a private company in its article. Any public company is there and it has a subsidiary A, that is a private company. So this A will also be considered as public company. That is what they have given. If a subsidiary is there of a public company, that subsidiary will also be considered as your public company. Okay. Now, significant points that they have given. Is not a private company, articles do not have the restricting clause. Shares freely transferable. Today you buy the shares, tomorrow you can sell them. Day after again you can buy the shares. No minimum paid up capital requirement. No minimum paid up capital. 100 crores, 10 crores, 2000 crores, any paid up capital can. Maximum number of minimum number of members is 7. Minimum 7 members should be there for a public company. Maximum there is no limit. 10 lakh, 20 lakh, 20 lakhs, 20 crore also people can be your shareholders. Subsidiary of a public company is deemed to be a public company. I explained you that if a subsidiary is there of a public company, it will also be considered as subsidiary of, it is also to be considered as public company. Even though it is a private company, still you will say it is a public company because it is subsidiary of a public company. Okay. Clear everyone?
Yes, ma'am.
Okay, let's go ahead. According to section 3(1)(a), a company may be formed for any lawful purpose by 7 or more persons where the company to be formed is to be public company. So if you want to make a public company for a lawful purpose, something that is recognized by law, you can make a public company with 7 or more people. Okay. Now, on the basis of control. Now, if one company is controlling the other one, you can call it as holding or subsidiary company. Holding and subsidiary companies are relative terms. A company is a holding company in relation to one or more other companies, means a company of which such companies are subsidiary companies. Now, A Limited has 55% shareholding in B Limited. So A Limited will be called as the holding company and B Limited will be called as subsidiary company. Subsidiary means the company which is held by some other company. They have given the definition. Let's see. For the purpose of this clause, the expression company includes any body corporate. It can be any body corporate. Section 287 defines subsidiary company in relation to any other company, that is to say the holding company, means a company in which the holding company controls the composition of board of directors, exercise or controls more than 1/2 of the total voting power, either at its own or together with one or more of the subsidiary companies. Now here, I told you they have 55% of shares. That means they are holding the voting power. Total 1/2 of the voting power is there with A Limited. Or else if A Limited is controls the composition of board of directors, appoints 10 out of 12 directors of B Limited. Now 10 directors are appointed by whom? A Limited. That means major directors are under the control of A Limited. Controls the composition of board of directors. Who will be the director or not? A Limited will tell us. So that is where you can say A Limited is controlling the composition of board of directors. Provided that such class or classes of holding companies as may be prescribed shall not have layers of subsidiaries beyond such members as may be prescribed. So they can't have multiple layers of subsidiaries. There will be some specified limit given by the government. That much subsidiaries only you can have. There shouldn't be layers or layers. Like A Limited is the holding company of B Limited. B Limited holds C and D. Now C Limited again holds E, F, G and H. Then again B Limited is holding M Limited. So M Limited is again having N, O and P. These 3 companies. So this multiple layers cannot be there. They will give some limit. Till that time layers only you can have a holding and subsidiary relation. For the purpose of this section, a company shall be deemed to be a subsidiary company of the holding company even if control referred to in subclause 1 or subclause 2 of another subsidiary company of the shareholding. If here A is having the control of B and C. So B is also having the control of D and E. Here, D will also be considered as subsidiary of B because B has entire holding in D. That is why you can say B is controlled by A and D is ultimately undoubtedly controlled by A. Okay. Is this point clear? This is very important for you people.
Clear, ma'am.
Composition of a company's board of directors shall be deemed to be controlled by another company if that other company, by exercise of some power exercisable by it as discretion, can appoint or remove all or majority of directors. I told you it appoints 10 out of 12 directors. So here major control is there of A Limited on B Limited because 10 out of 12 directors of B Limited are appointed by A Limited. They have the power. They can either appoint or remove all or majority of directors. Here majority is 10 directors. So A has power to appoint major 10 directors of the company, or A can remove all these 10 directors. So that time you can say your B Limited is a subsidiary and A Limited is a holding. The expression company includes any body corporate. Layer in relation to a holding company means its subsidiary or subsidiaries. This is layers. A has B subsidiary, B has D subsidiary. Some example is given. A will be subsidiary of B if B controls the composition of board of directors of A, that is, if B can, without the consent or approval of any person, appoint or remove the majority of directors. Here they have given different, like opposite. B controls the composition of board of directors of A Limited. So here you can say B is the holding company and A is your subsidiary company. A will be subsidiary of B if B holds more than 50% of share capital of A. Now, if B is holding more than 50% of share capital of A, that means if it is holding 52%, B will be controlling A Limited. Okay. Are the examples clear?
Yes, ma'am.
Let's go ahead. B is a subsidiary of A and C is a subsidiary of B. B is a subsidiary of A and C is the subsidiary of B. C is the subsidiary of B. In such a case, C will be the subsidiary of A. Here, C will be subsidiary of A. As I told you earlier also. In the like manner, if D is subsidiary of C, here D is subsidiary of C. D will be subsidiary of B and D will be also subsidiary of A. Because subsidiary is the subsidiary of the holding company. Okay. Is this point clear?
Yes, ma'am.
Yes, ma'am.
Status of private company which is subsidiary to public company. In view of section 271 of Companies Act 2013, a private company which is subsidiary of a public company shall be deemed to be public company for the purpose of this act, even where such subsidiary company continues to be a private company by its article. If A Limited is a public company and it holds B Limited as subsidiary, then you can say that B Limited is also a public company. B Limited will also be considered as a subsidiary company and it is also be called as public company. Then next what we have is your associate company. In relation to another company means a company in which that other company has a significant influence, but which is not subsidiary company or the company having such influence and includes a joint venture. Here, A Limited can appoint 6 out of 10 directors, right? 6 out of 10 directors, or you can say 4 out of 10 directors and has 40% stake. That means it is an associate company. Associate company because there is significant influence. There is significant influence, great power to control. That means if it is significant influence means control of at least 20% of the total voting power. More than 20% if control you have of any company, B Limited. So B Limited will and A Limited will be associate companies. Or control or of participation in business decisions under an agreement. If you have 20% or more of voting power, or you can control or participate in the business decisions of some other company, you can call these two companies as associate company. Okay, is the definition of associate clear?
Yes, ma'am.
Joint venture means a joint agreement whereby the parties that have joint control of the arrangement have rights to the net assets of the arrangement. If two companies come together, A Limited, B Limited, come together and they form a construction company, right? These two are coming together and forming a construction company, AB Limited. So this is a joint venture. Two people have come and jointly control the rights of the net assets of the arrangement. Whatever revenue will be generated by AB Limited's revenue will be shared by A and B Limited. Okay, that is called as joint venture. Are we clear till here? Any doubts till here? Should we move ahead? On the basis of access to capital, listed company. If the people in the country have the access to the shares of the company, this is called as a listed company. You have the access to the capital. You can invest in that capital. So you can be said to having access to the capital. That means it is a listed company. As per definition given in section 252 of the Companies Act, it is a company which may have any of its securities listed on any recognized stock exchange. If your company has any listed securities on the stock exchange, you are called as listed company. Securities listed on the stock exchange will be called as listed company. Anyone can go and buy the shares from your registered recognized stock exchange, provided that such class of companies which have listed or intend to list such class of securities as may be prescribed in consultation with the Securities and Exchange Board shall not be considered as listed companies. If some companies have been given as a list, they will not be considered as listed companies by SEBI, Securities and Exchange Board of India. SEBI says that these are not going to be considered as listed company. Such companies will not be considered as listed companies. Whereas the word securities as per section 281 of Companies Act has been assigned the same meaning as defined in clause H of section 2 of the Securities Contract Regulation Act 1956. So securities can be anything. Your debt can be a security. Your shares can be your securities. Example is given. Scan Steel Rods Limited is a public listed company whose shares are listed in the stock exchange, Kolkata. Hence, Scan Steel Rods Limited is a listed company. Their shares are listed. Shares are listed. Shares are listed on what? Stock exchange in Kolkata. So in any of the stock exchange, if you are registered, then you can say that you are a listed company. The reason of calling it listed is because the company and the stock exchange have signed a listing agreement for trading of shares in the capital market. They have signed the listing agreement. They said that, okay, show our name in the list. Now we buy some products on Amazon, Flipkart. We see that the name is given. That is listed on the Amazon, Flipkart. That is why if the company agrees to list itself, makes a listing agreement for trading of its share, we can buy those products because they have listed on Amazon, Flipkart. That is why that is similar to this case where shares are listed for trading on the in the capital market. That time you can say it is a listed company. Okay, is listed company clear?
Yes, ma'am.
Okay. Unlisted company means company other than listed companies. Companies which are not listed on any of the stock exchange will be considered as unlisted company. Government company where not less than 51% of paid up share capital is held by central government, by any state government or governments, partly by central government and partly by one or more of state governments, and the section includes a company which is a subsidiary company of such government company. So if 51% of paid up share capital, 51% or more of paid up share capital is held by central government or state government, or by central government, state government and central government, half is held, or any in the ratio 20 and 35. So this is the ratio held by them. So you can still say this is a government company. And any subsidiary of government company, A Limited is a government company. So if B Limited is subsidiary, B Limited will also become government company. Okay. If any subsidiary is there of a government company, it will be considered as government company. For the purpose of this clause, paid up share capital shall be constituted as total voting power where shares with differential voting rights have been issued. Here, paid up share capital is 51%. That means government has control in making the decisions. They have the power to vote over here. Government company, at least 51% of paid up share capital held by central government, state government, or partly by central and partly by one or more of state government. Here it can happen A Limited, the shares are held by central government 20%, Hyderabad, oh sorry, Hyderabad not, Telangana government 30%, and Maharashtra government 10%. So here still it is going to be a government company. 20, 30, 10. So one or more of the other state governments also is allowed. Okay. Clear with government company?
Yes, ma'am.
Foreign company, it means a company or body corporate incorporated outside India, which has a place of business in India, whether by itself or through an agent, physically or through electronic mode, conducts any business activity in India or in any other manner. Here, Facebook, Meta, you might have heard. Facebook now has become Meta. So if Meta is registered outside India, let's suppose it is registered in USA, has place of business in Kerala, place of business in Chennai. Now, if it has place of business in India, whether through itself or through its agent, here the place of business in Kerala is of Facebook office. This is Meta office. This is run by an agent. It also has a place of business in Bangalore. And this is run by electronic mode. Right? This is run by an electronic mode. They have an electronic mode having the office place at Bangalore, but it is run through electronic mode. You can just come and deposit the checks over here. No person is available at the office. Just a place is there where you can go and collect the business. Like go and do the business. That is also going to be considered as foreign company. Conducts any business activity in India in any other manner. And they are doing the business in India. Meta is doing business in India. That is why it will be considered as foreign company. Body corporated, incorporated outside India, which has place of business in India, whether by itself or through agent, physically or through electronic media, and conducts any business activity in India in any manner. That is your foreign company. And then we have your Section 8 companies. Section 8 of the Companies Act deals with formation of companies which are formed to promote the charitable objective of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, etc. Your colleges, schools, hospitals, your yoga centers. They are all your Section 8 companies because they are promoting social welfare, commerce, art, science. They are promoting the sports education, your sports bodies, etc. Voice is breaking now also. Is the voice still breaking?
Yes, ma'am.
Okay, 1 second. Let me switch the network. Is the screen visible?
Yes, ma'am.
Yes, ma'am.
Okay. The voice is breaking now.
No, ma'am, it's clear.
Okay. So your school, colleges, hospital, yoga centers, then your temples, etc. will all be included in your Section 8 companies. Such company intends to apply its profit in promoting its objective and prohibiting the payment of any dividend to its member. Whatever money they collect from the members or the donations, etc., they are going to use it to promote its objective. Suppose the Balaji temple, its objective is to promote religion and its objective is to promote faith in God. So they will be doing activities for promotion of this objective. If there is a hospital that is doing work for the welfare of the people, so it has to use the money in the profits of that business is to be used for making more beds, more hospital rooms, bedrooms of hospital, like they make more rooms in the hospital for the patients. They should make more services available. They should make more ambulances, get more ambulances to work, etc. So anything you're doing for promoting of objective, your profit is being applied for that thing, and you're not going to pay any dividend to the members. You're not going to give them any benefit out of the profits. That is when you can say it is a Section 8 company. Okay? Formation of company with charitable objectives. Clear, everyone?
Yes, ma'am.
Yes.
National Sports Club of India, SSOCM, FFICI, CII, all these are examples. You can read the full forms of them whenever you want. Not much relevant. Power of central government to issue the license. Section 8 allows the central government to register such person or association of persons as a company with limited liability without the addition of the word limited or private limited to its name by issuing license on such conditions as it deems. If the central government is satisfied that the reason why you are getting registration under Section 8 is for promoting commerce, art, science, sports, education, your social welfare, religion, etc., then they will give you a license. You have to take the license from central government. Registrar shall on application register such person or association of person as a company under this section. Some people will go and talk to the central government and tell them we want to form a company which is a Section 8. So the central government will approve and tell the registrar, okay, register them as Section 8 company. On registration of the company shall enjoy same privileges and obligation of a limited company. So any limited company, what are the obligations? They have to file the returns, annual returns, maintain the register, etc. All these compliances will be same on the Section 8 company, and it will enjoy all the privileges of Section 8 company. Now, revocation of license. If central government feels that you are not complying with the objective of trade, commerce, promoting the commerce, science, art, education, health benefits, religion, etc., then they can revoke your license. Revoke means cancel your license. Central government may by order revoke the license of company where the company contravenes any of the requirements of the conditions of this section, subject to which a license is issued or where the affairs of the company are conducted fraudulently. If you are running a hospital and doing frauds, then company will registrar or the central government will cancel your license. Or violate of the objects of the company or prejudicial to the public interest. If we still continue you as a hospital, that will be bad for the public. Public will lose the faith in the central government. That is why they cancel your name, because you have done some fraud. On revocation, registrar shall put limited or private limited against the company's name in the register. Now what registrar will do? He will not cut your name. He will not cancel the company. He will just write, now this is not Section 8 company, but this is a limited company or private limited company. But before such revocation, central government must give it a written notice to its intention to revoke the license and opportunity of being heard. Before central government cancels Section 8 license, they have to send a written notice to the company and also give the members of the company a right to be heard, an opportunity to be heard. Order of central government, where a license is revoked, then the central government may in the public interest order that company registered under this section should be amalgamated with another company registered under this section having similar objectives to form a single company with such constitution, properties, powers, rights, interests, authorities, and privileges, and with such liability and duties, obligations as may be specified in order to order the company to be wound up. Now, what they will say, central government will say your license is cancelled now. You can merge into another hospital. You are not going to be individual hospital now. You can go and join other hospital or else close down your hospital, close down the company. Okay, these two options government will give you, central government will give you. Penalty, punishment that government will be levying, because you said that you will work for the nation, you will work for the poor people, but you are not working. So they will give you some penalty also. If a company makes any default in complying with any of the requirements laid down in section, company shall without any prejudice to any other action, without considering any other action under the provisions, be punishable with a fine which shall not be less than 10 lakh rupees, but which may extend to 1 crore rupees. And the directors and every officer of the company who is in default shall be punishable with a fine which shall not be less than 25,000 rupees, but which may extend to 25 lakh rupees. Now, here, if company defaults, company has to pay a penalty of 10 lakh, and this can go up to 1 crore. And director who has done something wrong, because company is run by director, so director or officer, if they do something wrong, they have to pay rupees 25,000, which can extend to 25 lakh. Right? You have to remember this penalty limits. Provided that when it is provided that the affairs of the company were conducted fraudulently, every officer in default shall be liable. If there is a fraud done, then all officers will have to pay this penalty. Section 8 significant points. Let's just wind up the Section 8 company. Formed for the promotion of commerce, art, science, religion, charity, protection of environment, sports, etc. Minimum share capital does not apply. Use its profit for promotion of objective for which it was formed. Does not declare dividend on members. You don't have to declare the members any dividend. Operates under a specific license given by central government. Need not use the words limited or private limited in a name. Adopt a more suitable name as club, chambers of commerce, etc. You can use Rotaract Club, Lions Club, these type of clubs name you can use. License revoked if conditions contravene. If you contravene any condition, your license will be revoked. On revocation, what will happen? Central government may direct it to convert its status and change its name. It will tell him, convert the status and put the words limited or private limited in your name. It will also ask, you can get the winding up done, or you can amalgamate with another company having similar objective. Your hospital can get combined with other hospital. Can call its general meeting by giving a clear 14 days period instead of 21 days. Usually you have 21 days to give the notice, but in the Section 8 company, you can also give the notice of 14 days. Requirement of minimum number of directors, independent directors does not exist. You don't have to have minimum number of 2 directors, 5 directors, or any independent directors. This you will be learning in your Companies Act in your finals and your intermediate examination. Need not constitute nomination and remuneration committee and shareholders relationship committee. Again, this is a CA final concept. A partnership firm can be a member of Section 8 company. Your Section 8 company can have the members, which is a partnership firm. Okay. You don't have to make a committee for giving the remuneration, for nomination of employees or shareholders nomination. You don't have to make any such committee. Okay, let's take a recap of Section 8. To promote charitable objective, application, the money should be used for objective. No payment of dividends, limited liability company without the addition of words limited or private limited. Central government may grant such status. Central government has delegate the power to grant this license to ROC. ROC will give the license because central government has given the right to ROC. Revocation. Central government may revoke license if conditions of Section 8 are contravened. You are not running the hospital for charity. You are doing it for frauds. Affairs of the company are conducted fraudulently or prejudicial to public interest. You are harming the public interest. Then also you will be held liable and Section 8 company will not continue. Effect of revocation. If the license is revoked, you have to use the words limited or private limited, or else they will ask you to wind up, or else they'll ask you to amalgamate in another company. Is Section 8 company clear to you people?
Yes, ma'am.
Clear? Okay, let's go ahead. Dormant company. Dormant company is a company which is formed and registered under this act for a future project or to hold an asset or intellectual property and has no significant accounting transaction. Such a company or an inactive company may make an application to the registrar in such a manner as may be prescribed for obtaining the status of dormant company. Now, dormant companies are the sleeping companies. We have seen dormant partner in the previous chapter, dormant partner in the Partnership Act. Similar way, there is a dormant company. They are not going to function. They have just they are just holding an asset. Like if a company is having a building, they are just going to take the rent of it, and the rent will be having any interest out of it. They are just holding the property. They are not taking the rent also. That is also considered as your dormant company because these are inactive company. There is no significant accounting transaction. No accounting transaction is being done over here. Right? That is called as your dormant company or any inactive company which is functioning like the company was working from 10 years. Now they are not working anymore. No sales, no purchase, nothing is happening. So that will be considered as inactive company. Inactive company means a company which has not been carrying on any business or operation or has not made any significant accounting transaction during the last 2 financial years. The inactiveness should be for last 2 financial years. You have to be inactive, not working for last 2 financial years, or has not filed the financial statements or annual returns during the last 2 financial years. You have not complied with the company requirements of filing your financial statements or annual returns for the last 2 financial years. Then also your company will become inactive because you have not filed any return, income tax return, annual return. You have not filed for 2 years, and from 2 years you are not doing any sale, purchase, etc. So that is why you'll also be considered as inactive company, which is a dormant company. And if you want to become a dormant company, you have to go and apply to the registrar. Tell them we have been inactive for 2 years. Now give us the status of dormant company. Let's see what significant accounting transaction means. Any transaction other than. So these are not significant transactions. Other than this, if any transaction you're doing, that will be considered as significant accounting transaction. But these transactions will not be a significant accounting transaction. Payment of fees by a company to the registrar. This is allowed. This is not a significant accounting transaction. Payment made by it to fulfill requirements of the act or any other law. You pay the company's registration fees. That will be allowed. Allotment of shares to fulfill the requirement of this act. You have to give the shares to the people. So that is also allowed. payment for maintenance of its office and records. You give the sweeping charges, electricity bill of the office, you maintain the records, you give the accountant their fees for maintaining the records, for filing the returns. That is not your significant accounting transaction. Significant accounting transaction means sales, purchase, interest, rent, revenue. If you are getting anything, that is your significant accounting transaction. Is dormant company clear to you people?
Yes, ma'am.
Let's go ahead and see Nidhi company. In this section, Nidhi or a mutual benefit society means a company which the central government may by notification in official gazette declare to be a Nidhi or a mutual benefit society as the case may be. Nidhi companies are created mainly for cultivating the habit of thrift and saving among its members. Now, you might have heard your parents save the money and with few of their friends they collectively invest in some activity, or they collectively use that money, they spend some they come together and have a party kind of thing, and then there they share the money, then they give the money and keep it with themselves or deposit it in any bank. So that is called as Nidhi company. You have heard the word kitty party kind of thing? Have you heard kitty party kind of thing?
No, ma'am.
No, not heard. Okay. So what happens is few of the members in a society, they come together and they say like, I have 5,000. Every month we will collect 5,000 each. 10 members are collecting 5,000 each. So they will deposit this 50,000 in the bank and get the interest out of it. Or this 50,000, they will give it to Mr. A. Like these 10 members are there, or 5 members are there, 10,000 each they are giving every month. So every month they are giving. Now in this month this person will get 50,000, next month this will get total 50,000, this month this will get total 50,000. So this is how Nidhi company operates. Mutual benefit society,
Ma'am, it's
everyone will,
more like self-help groups.
yeah, self-help kind of groups. They come together for the mutual benefit of each other. Like if I have a wedding at my house and I want some money and I have been investing 10,000 per month with other people. I used to give 10,000 every month to them. And one of them used to take the money every month. So now it is my turn. If I want the money, I will tell them, this time you give money to me. All the money you collect and give me. So in lump sum, I will get 50 lakh rupees or 50,000 rupees. Earlier, I used to get give only money. One used to get the money. Now I need the funds, so I can ask them. Okay, is the Nidhi company concept clear?
Yes, ma'am.
Let's go ahead and see public financial institution. By virtue of section 272 of the Companies Act 2013, following companies are to be regarded as public financial institutions. Life Insurance Corporation of India, established under the LIC Act. Life insurance company, this is a public financial institution. It is helping the public to maintain their money, how they have to get the benefit. All these things are being done for the public. So they will be called as public financial institutions. Infrastructure development finance companies, they help in building the houses, and you can buy some shares out of the property that is there. Specified company referred to in it, Unit Trust of India. Unit Trust of India, Transfer of Undertaking and Repeal Act. Institutions notified by central government under section 4A2 of the Companies Act 1956, so repealed under section 456 of this act. Now this has been changed to 456 of this act. Then such other institutions as may be notified by central government in consultation with Reserve Bank of India. Simple example which you can remember is LIC, or Infrastructure Development Finance Company Limited, IDFC Limited. So these are your public financial institutions, help to manage the public their money. But they need to maintain some conditions. No institution shall be notified unless it has established or constituted by or under any central or state government other than this act or the previous company's law. They have been established or constituted by or under any central or state government. You have to establish it in this constitution only. No institution shall be notified unless it has established or constituted by or under any central or state act other than this act or the previous company's law. You have been established under any other act other than the Companies Act 2013 or 1956. And not less than 51% of the paid up share capital is held or controlled by central government or by the state government or governments or partly by central government and state government by one or more of the state. So PFI will be controlled. 51% of the paid up share capital will be controlled by central government or state government, or half by state government and half by central government and half by state government. Okay. So it has to have 51% control of the governments, and it should be constituted under any other act, not the Companies Act 2013 or 1956, other acts. Clear?
Yes, ma'am.
Now, should we go to mode of registration, or you need a break or anything like that? 5-10 minutes you want? Because this might be a little heavy for you, like all the types of companies we discussed together. Okay, one message in the chat box. A long break. Okay. What time it is? 2. Okay. Let me see how many pages are we left with. Like how much content are we left?
We still have 20 pages to do it.
Still have 20 pages. Like, because we have only covered 3 points, so much of the content will be remaining. Okay, what do you say? When do we resume? When should we resume, everyone? Three is okay? Like it's 2 right now, right? 17. 5 o'clock. You want to resume at 5? Everyone, what do you say? 17 pages. Okay. Sorry. No, I was saying like, when do we resume? That you tell me, everyone. There are 3 people. Gopika, Meenakshi and Sharmita.
After 4.
After 4 you want? Okay. Others, what you think? Gopika, Meenakshi. (4:30) should we?
Yes, ma'am.
Okay, ma'am.
4:30 is okay for all 3 of you. Okay, let's resume at 4:30 and we'll try to cover it. Okay. That's it for this session.